Hi everybody, trademark attorney Josh Gerben. I'd like to answer a common question we get about trademark applications, and that is, what is an office action? So an office action is an action that is issued by the United States Patent and Trademark Office on a trademark application that has been filed. Typically what happens is once you file a trademark application, about 3 to 4 months later, it will be reviewed by a U.S. Patent and Trademark Office examining attorney. This is a real live individual, real attorney that works for the Trademark Office that's reviewing your application. So if the application does not meet all the technical requirements that the United States Patent and Trademark Office has laid out, or has a more significant problem like a likelihood of confusion with a pre-existing trademark, the examiner will issue this office action and ask you to either correct the technical deficiencies or inform you of a refusal of your application. So as I just mentioned, office actions tend to deal with two different things. One, the technical deficiencies in a trademark application, and two, any inherent problems with the trademark itself, meaning that it's too close to another trademark or for some reason isn't unique enough to qualify for trademark protection. So here are some common technical deficiencies that the USPTO will find in applications. The first is the identification of goods and services being technically insufficient. It is very common, especially for folks that file trademark applications on their own or for those applications coming in from countries outside the United States, that the language used to describe your products or services in the application is not fully technically there yet by the time you file the application. The government has very specific ways that they allow you to describe your goods and services, and if your language doesn't meet those rules, they will issue an office action asking you to make certain corrections or clarifications. Another very common technical office action is when an examiner seeks a disclaimer of a portion or all of your trademark. So think if you filed a trademark for Josh's clothing brand. That was the trademark, Josh's clothing brand. Josh's would actually be very unique and not require a disclaimer, but the phrase clothing brand is obviously very generic and anybody else needs to be able to use it. So the USPTO would require the trademark applicant to issue a disclaimer on the phrase clothing brand. And they would issue an office action saying, hey look, we need you to put this statement in your application that you're not claiming an exclusive right to the mark clothing brand apart from as it's shown, meaning with Josh's clothing brand. Now, a disclaimer requirement can be more serious if it's about your entire trademark, because if you have to disclaim all the words in your trademark, it's going to make it very difficult to enforce any of them in the marketplace. And the final, most common technical deficiency with an application is an improper specimen. So with every trademark application that's filed, you eventually have to prove to the government how you're using the trademark. And this requires submitting a specimen. It could be a photograph of your product. If it's a service-based business, many times a screenshot of your website. But it has to show the trademark being used in conjunction with the products or services. And this is a lot harder than it sounds because there's very technical ways you have to show this. And if the specimen you submit doesn't meet these technical requirements, you will get an office action asking to submit another specimen to show the government more about how you're using the trademark. So the next type of office action is a more serious one, and this is a substantive refusal of your application because of an issue with the trademark itself. This typically takes one of two forms. The first would be a Section 2D likelihood of confusion refusal. So if the USPTO thinks your trademark is too similar to somebody else's, they will issue this type of refusal called a likelihood of confusion refusal because they're saying your trademark would likely cause confusion in the marketplace if you used it while this other trademark is still there. These types of refusals can be relatively difficult to get around, but you can submit appeals to the USPTO to reconsider that type of refusal. You can even attack the validity of the trademark that's blocking yours if it's been abandoned or has some other type of inherent issue with its registration. The other type of substantive refusal you'll get is that the trademark is descriptive. It's merely descriptive under Section 2E1. So if you get a Section 2E1 merely descriptive refusal, the government's telling you that the trademark is not unique enough to register on the principal register. You may be able to amend these applications to register on something called the supplemental register. So there's essentially these two registers. You have the principal register and the supplemental register. And it is very much what it sounds like. You want to be on the principal register. That's where the most significant rights and trademarks come in. But if the trademark is truly descriptive, meaning it just describes your products or services and is not unique, you may consider taking a registration on the supplemental register because it still gives you the ability to use the circled R with your name and still will prevent others from registering identical trademarks to yours. So I hope this video helps shed some light on the trademark process and helps you understand what an office action is if you've received one. Of course, there's other types of office actions than the ones we've covered, and if you have any particular questions about your trademark or an office action you've received, please feel free to get in touch with us. Thank you so much, and I'll talk to you soon.